right. Plan a big surprise. Come on, fire one bag. Get it out. Now in 76.
Push out
You know my down that way. Function in the game. The way the moves are down.
I'm not ready to go yet, okay? I'm not ready. You gotta wait. I got shit to do. I'm in the middle of something, all right? Just hold on.
Watch your mouth or don't come in here.
Uh-oh. Uh-oh.
Oh yeah, people, come on, we're adults here.
You know what? What is the point?
Yeah, we're adults here. I got a fucking Burger King fucking thing on my head. We're all fucking adults here, guys. People in my chat, 2 words. What are they? 2 words. Let me see the chat flood. Let me see the chat flood. 2 words. Okay, next caller. Please. Let's get into the meat and potatoes, which translate in American to dick and balls.
I got flip-flops. These are my flip-flops. Yeah, I really like my flip-flops because I can put them on. Because look, watch me put them on. I can put them on all by myself. Watch me put them on. Look, are you watching? Look, these are my flip-flops.
Thanksgiving Day. I remember it clearly. It was Thanksgiving Day. I was inserting myself in somebody else's fucking business as a cash grab, and you know. This channel is harsh reality.
Karen Yak se jodió la sucia vida. Amen.
This is Jonathan Lee Richards. I have cheeseburgers. I'm gonna put cheese on them. I'm gonna make sure that I have my hamburgers because I'm a big boy now and I can make the hamburgers. My mom lets me use the stove now.
And I'm just like, wow, I like receipts, and they brought receipts. Like they had evidence to back up everything they said. And I'm like, okay, well, there's got to be another side to this, right? Like this can't. No, this is too fantastic.
Yeah, because you're not going to just jump to the conclusion that there's a conspiracy amongst cops to cover up a murder. You know what I mean?
Yeah, I mean cops and just like soccer moms and shit. Like that's what made it even crazier. Like,
yeah, get it, Betty. Yeah,
did you have a close relationship with your mom?
Get it, Betty.
Oh, of course, I still do.
Yeah.
My older sister was kind of sad. She was more of the prissy girl that likes going.
That is the best shit fucking
shopping
ever.
for dresses with mommy. I was the tomboy that liked playing with the feet.
Shout out to Cherry for just being easily the most faithful and loyal supporter that I've ever had. That someone could have that tenacity with loyalty. And I'm really blessed to have someone like Cherry be part of this channel and in my life. So it means a lot. And yes, I named him after Mr. T and Rocky. Say woman. Say woman. Say woman. Since your old man ain't got no heart, why don't you come down to my apartment tonight and I'll show you a real man. Oh my God, I'm so in love with this little dude. Yeah, I'm gonna go ahead and wrap this one up. I love you guys very, 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 very much. And we will do this again very soon, my friends. Oh, say bye. Say bye. Oh, I love you too. Give me a kiss. Oh, I love you. Bye, guys. Woo! Good afternoon, folks. Oh my goodness. Oh, it's good to see you guys, man. Seriously. It's great. It's gonna be great to break the tension from that last stream. Oh my goodness. Seriously. Yeah, got a lot to talk about.
I think we got a super cat. Super cat. I think we got a super cat. Super cat. super chat. Super chat. I think we got a super chat. I think we got a super chat.
Little Irish girl, thank you so much. I appreciate you. Yeah, I missed you too. So what we're gonna go over today, the defense, Karen Reed's defense, filed a response to the opposition motion filed by the prosecution, which was a response to the defense's motion to dismiss on the grounds that jurors had come forward, and jurors have come forward and stated that on counts 1 and 3 they were unanimous in a not guilty verdict for Karen Reed, and yet this was declared a mistrial. And due to the fact that the foreman sent a note, and the foreman turns out to be an ex-police officer, turns out, thanks to the investigations of Turtle Boy, as usual. This is and now I haven't read it yet. I saw that Sleuthy posted it. I reposted it so that I could find it, basically, so that I could just click on it quickly. But I have not read this yet. And Cherry found me a original copy of it, so I'm gonna go ahead and pull that up. Now there's been some there's been some interesting stuff, right? There's been some interesting stuff that have taken place. It turns out that Plevin has a Reddit. Now I don't really use Reddit a lot. I think the last time I commented on a Reddit thread was, man, months ago. But yeah, I don't do Reddit much. And we also there's also a tweet from Turtle Boy that I want to go over too, that I thought was pretty interesting. And I have some thoughts on that. And I think I'm in complete agreement with him on what was going on there, because you guys know I've been pretty vocal lately about, a lot of these and I don't want to call court TV mainstream media, because they're not, but the thing is they have a lot of reach, and people tend to think that they're mainstream media. I mean, we know what they are, you know what I'm saying, but most people don't. You know what I'm saying? Little Irish girl, thank you so much. Team Brittany and Scott, you're awesome too. Carry on, Will. Thank you so much. I appreciate you. Yeah, so but we'll get into that in a little bit. Now, before I continue, I have a members only live scheduled after this, I think at 5. I have a members only live now. The reason why it's members only is because it's not the usual content that I do, and I don't really expect a whole lot of people. And I want the members to be able to have some privileges. So since it's content that I don't normally talk about, I'm going to it's going to be members only who can comment. It's available for everyone to see, but unless you're a member, you won't be able to comment. So it's exclusively for members only as far as commenting goes, because I expect it's going to raise some controversial opinions, and I'm going to discuss the recent, what seems to be a cancellation of Tenacious D. And I am I am very, very fascinated by this. I have a lot of thoughts on this. So I'm gonna discuss that. So and my loca, yes, there you go. If this is something that you got thoughts on and you want to comment on, become a member and come join. And to those of you who are members already, I hope to see you guys there, and I hope that you enjoy the exclusivity. Because yeah, I don't know what it is, man. Like I tend to like to shoot myself in the foot a lot. And right now we're in times where I have thoughts on things, and I got a big mouth, and it is what it is. So I want to be able to talk about that stuff. Now, oh, who is on my shirt? You guys, I mean, how do you not recognize the GOAT? That is the GOAT, people. Mr. Eddie Van Halen. All right, so we're gonna get into this. We're gonna get into this this response from the defense. Because I expect on the 22nd that there's going to be some interesting this hearing is going to be very interesting. But I am very, very interested in seeing this. All right. All right. So the Commonwealth of Massachusetts, Superior Court, Norfolk, defendant Karen Reed's reply to the Commonwealth's opposition to her motion to dismiss. All right. Now, sorry guys, I have a new mic, and it doesn't have the feature where I could just tap it and it mutes. So I have to kind of reach over here and then mute manually. So you might hear noises that I normally mute myself, such as swallowing and slurping of my coffee. So yeah, just a warning. But I am making an effort to mute anyway. Now comes the defendant Karen Reed by and through undersigned counsel, and hereby respectfully submits this reply to the Commonwealth's opposition to her motion to dismiss. The Commonwealth's opposition is perhaps most notable for what it does not dispute, that according to information from 4 deliberating jurors, the jury had reached a unanimous decision that Miss Reed is not guilty on 2 of the 3 charges pending against her, namely counts 1 and 3. The Commonwealth's insistence that Miss Reed must nonetheless be forced to run the gauntlet once more is based on several clear fallacies. Green versus the United States, blah, 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 blah. Hippie Chick, thank you for becoming a member. Welcome to Logic. The Commonwealth's insistence that Miss Reed must nonetheless be forced to run the gauntlet once more is based on several clear fallacies. First, while the defense was given an opportunity to be heard on other issues arising during jury deliberations, i.e. the appropriateness of a Tui Rodriguez instruction, the defense was provided no opportunity to be heard regarding the declaration of a mistrial. Rather, upon receiving the final jury note, the court sua sponte declared a mistrial with no warning to or solicitation of objections from the parties. Second, the jury's note did not explicitly indicate an impasse on all charges. It did not, right. Opposition at 1, to the contrary, it was readily susceptible to the interpretation proven correct based on information received post-trial from deliberating jurors that the deadlock applied only to the multiple offenses included within count 2 and not to counts 1 and 3. Third, and finally, the defense respectfully submits that neither the Commonwealth nor the court carefully considered alternatives before declaring a mistrial. The record reflects no discussion of any alternatives, including, importantly, inquiry regarding whether the jury had reached an impasse on all as contrasted to just some of the counts. The underlying idea of the constitutional protection against double jeopardy, one that is deeply ingrained in at least the Anglo-American system of jurisprudence, is that the state with all its resources and power should not be allowed to make repeated attempts to convict an individual for an alleged offense. Even if the first trial is not completed, a second prosecution may be grossly unfair. It increases the financial and emotional burden on the accused, prolongs the period in which he or she is stigmatized by an unresolved accusation of wrongdoing, and may even enhance the risk that an innocent defendant may be convicted. Consequently, as a general rule, the prosecutor is entitled to one and only one opportunity to require an accused to stand trial. Arizona versus Washington, blah, 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 blah. United States versus Martin Linen Supply. At the heart of this policy is the concern that permitting the sovereign freely to subject the citizen to a second trial for the same offense would arm government with a potent instrument of oppression. Wow, well said. Thus, whether the jury acquitted Miss Reed or alternatively was merely not deadlocked on the relevant counts, the Constitution compels the same result, dismissal. Given the unambiguous post-trial evidence, it would simply be wrong to require the defendant to obtain two acquittals from two different juries for the same crime. Exactly. Exactly. See, in the Commonwealth's opposition, they talked about, it was very interesting in the sense that they did this whole, as I stated before, look over here, don't look over here. As Jackson stated in his closing arguments, the first thing he said in his closing arguments. So what they do here, or what the opposition did, they didn't even dispute the actual issue. What they did was they said, oh, well, they got on the defensive of the implication from the public's view, which was that something was amiss and something was dirty, because they jumped to the defense immediately and are like, oh, well, we're, this is all hearsay. And, we're just hearing rumors from people, blah, blah, blah. Instead of actually really pointing out the actual issue, is that, and they actually lied, and they said that Beverly Cannoni gave them ample opportunity to object, which she did not. We watched it. I went over it day before yesterday. We watched it. Or the last, not day before yesterday, the last live stream I did before the last one. But I mean, they straight up lied. Lally straight up lied in his opposition motion because we watched it happen. And it wasn't that Yannetti pushed for a mistrial. What Yannetti did was he pushed for her to give the Tui Rodriguez instructions to the jury, to push on that. But not to declare a mistrial. The Commonwealth's leading argument is rooted in pure formalism, that no verdict was entered on the record in court. Opposition at 5, but precisely the formalistic mode of analysis has been consistently rejected by the United States Supreme Court and Supreme Judicial Court in a string of precedents spanning more than 100 years. The reception of the verdict and discharge of the jury is but a ministerial act involving no judicial discretion. However, it may be in England in this country, a verdict of acquittal, although not followed by any judgment, is a bar to subsequent prosecution for the same offense. Holding that judicial grant of new trial prohibited retrial on double jeopardy grounds, now withstanding that the state Code of Criminal Procedure did not authorize trial judges to enter judgments of acquittal in jury trials. Indeed, the prohibition against double jeopardy was plainly intended to condemn the abhorrent practice of English judges exercising a power to discharge a jury whenever it appeared that the Crown's evidence would be insufficient to convict. Wow. The Commonwealth's heavy reliance upon Bluford versus Arkansas fails for reasons set forth in the defense's opening motion. See motion at 6. In that case, after the foreperson reported that the jury was unanimous against conviction on certain charges, the jury was sent back to continue deliberations. The foreperson's report was not a final resolution of anything, and there was no indication at the conclusion of deliberations that it was still the case that all 12 jurors believed the defendant was not guilty of capital or first-degree murder. Here, by contrast, 4 deliberating jurors attest that there was a final unanimous agreement that Miss Reed is not guilty of second-degree murder, persisting through the conclusion of deliberations. According to one such juror, Juror D, after the juror was excused and aboard the bus, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen Reed on count 1 and 3? Alan Jackson supplemental affidavit. Excuse me. Alan Jackson supplemental affidavit. I guess it's like chapter 8 or the second entry or something like that. Most importantly, unlike Bluford, this was not a case where the defendant was charged in a single count which incorporated lesser included offenses. Indeed, the Arkansas law at issue in Bluford did not even permit the jury to return partial verdicts of acquittal, noting that the jury's options were limited on 2, either convict on one of the offenses or acquit on all. Here, by contrast, the defendant was charged with 3 stand-alone counts, and state law expressly allowed for partial verdicts on any charges with respect to which the jury was agreed. Right. Only if the jury, in fact, was deadlocked on all 3 should a mistrial on all 3 be declared. Any other result would require either a verdict if a unanimous one had been reached, as the affidavits in this case reflect, or at minimum, further deliberations. See, right there, that right there tells me that, I mean, if the state law is this, if that's the state law, then that's the state law, period. If that's the state law, then, because again, I have to sit here and wonder, like, I hear some law tubers go, well, Judge Beverly Cannoni, she's a judge. She has immunity. She can do whatever she wants. She can declare a mistrial. But if it's actually against the law, then what can happen? Can she be reprimanded in some way, shape, or form for this? What is the point of having laws if judges can do whatever the fuck they want with them? That doesn't make sense. So I'm very, very curious. I mean, they're making it plain and simple here. You cannot call a mistrial if the charges are not unanimous. If they're or if each charge, if there's different unanimous decisions with the jury for each charge, you can't. If there's 3 different charges, you cannot just call a mistrial automatically on all 3 charges when they actually sat back there and deliberated and unanimously said not guilty on 2 out of those 3 charges. It doesn't make sense. See, the big question here, what needs to be focused on, in my opinion, is this very simple. I mean, they're reciting the law. That's it. This is how the Commonwealth of Massachusetts works. Period. This is how it is. So you can't retry her for those charges. And the second thing is, it raises the question, well, we never knew. But why did we never know? Why did we never know that there were different decisions, different votes for for different charges? So why didn't we know that? And it seems because Judge Beverly Cannone rushed it. Cannone rushed it and says, okay, I'm not going to do that to you folks. I'm going to go ahead and call this a mistrial. Okay. I mean, that's all she did. So everybody was just kind of like, wait, what? Okay. But everyone was expecting to hear her call a mistrial. So that's probably why nobody went, wait a second, what the fuck is going on here? Because everybody was just kind of expecting her to call a mistrial. Now, should the defense have gotten up and objected? Well, sure. But that doesn't change the fact that these jurors came forward on their own volition. They came forward to admit that they and that it troubled them, that they left, that they were dismissed. And once they got on the bus, they're like, is anybody going to bring up the elephant in the room here? That she called a mistrial and this woman's going to get retried when we all, the jury, unanimously decided that she wasn't guilty of second-degree murder? Is anybody here going to talk about this? Can you imagine what the vibe was on that bus? That's insane. Yeah, so only if the jury, in fact, was deadlocked on all three should a mistrial on all three be declared. Any other result would require either a verdict, if a unanimous one had been reached, as the affidavits in this case reflect, or at minimum, further deliberations. The lack of manifest necessity to support a mistrial provides a second independent basis for dismissal. While there is no doubt that a jury deadlock may constitute manifest necessity, the Commonwealth unsurprisingly cites no support for its contention that a deadlock on some, but not all, separately indicted charges supports declaration of a mistrial with respect to all counts. Contrary to the Commonwealth's characterization as unambiguous, opposition at 7, the jury note at issue here was facially susceptible to two alternative interpretations. One, that the jury had reached an impasse as to all charges, or two, that the deadlock applied to only some of the charges on multiple lesser included allegations within a single count, such as count 2. The information received from jurors post-trial proves the latter interpretation was correct. Right. I mean, that's the whole point. There's two different ways of looking at it here. Is either the jury reached an impasse on all charges, and that's how she just assumed the note read, or two, that the deadlock applied to only some of those charges on multiple lesser included allegations within a single count, such as count 2. The information received from jurors post-trial proves the latter interpretation was correct. The jury's failure to expressly mention its agreement on counts 1 and 3 is understandable in light of the court's instruction that it should continue deliberating until it had reached a final verdict on each charge. June 25th, 2024. Given that there was no deadlock on two of the three counts, it follows that there was no manifest necessity to dismiss the jury without receiving its verdict on those two charges. The defense does not suggest that the court was required to give the jury new options for a verdict. Bluford 566 U.S. at 609, only that it should have asked the straightforward question of which of the separate indictments the professed deadlock related to. Right. So that's the whole point here, is the fact that the judge never ever specified this. The defense does not suggest that the court was required to give the jury new options for a verdict, only that it should have asked the straightforward question of which the separate indictments the professed deadlock related to. That's exactly the issue. That's exactly the issue. That's all it is. So why didn't Bev make that distinction? Why wasn't she more thorough? In essence, the Commonwealth's conscience. See, this is the thing: is Bev's going to have to, in order for Bev to make a decision in favor of the defense in this case, which I would never expect her to, even though it's clear as to why she should, but I would still never expect her to, because why would I at this point? Why the fuck would I? So when I look at when I look at this right here and what they're saying that okay, you should have just simply caught this. That's your job. That's your job to ask the jury, okay, well, which are you specifically deadlocked on certain charges, or are deadlocked on all three of them? I mean, it was a simple move that Judge Bev didn't do. And this is the reason why I don't think that Judge Bev will rule in the defense's favor, besides the obvious reasons that I just pointed out. It's the fact that in order for Judge Beverly Cannoni to have to rule in Karen Reed's defense's favor on this motion means that she has to admit to a mistake. And I just don't see her doing that. That means that she's going to have to fall on her sword to some degree and say, oops, I slipped. I should have asked about those three charges, and I didn't. Now, what I can also possibly expect is her to go, well, I slipped, I should have asked, but the problem is that we are where we are now. We are where we are now. I already called the mistrial, and we're just going to have to move forward to another trial here, which I could totally see her doing. I don't know why. I don't even know if that's legal, but I could totally see her doing that, because I'm shocked at the shit that I've seen her do. But I mean, yeah, her decision could be appealed, sure. I mean, but yeah, I would imagine that's going to be the next move would be appellate court, and they're probably already going through the motions to get there. I would not put it past them. It's actually exactly what I would expect of Karen Reed's defense team, is to already be preparing for appellate court. I agree. Oh my goodness.
I think we got a super chat. Super chat. I think we got a super chat. Super chat. Super chat. Super chat. I think we got a super chat. think we got a
Miss Holmes, thank you. I personally would love to see the foreman's phone records since Bev called a mistrial. Wonder who he has been talking to. Maybe Bev or the McAlberts. I mean, there is that factor. Now, I don't have any evidence of this. I really don't. And thank you, Miss Holmes 66. I appreciate it. I don't have any evidence of this at all. But I feel like I'm justified in my suspicions, considering that within those texts, I mean, if we believe that this is how the jury unanimously voted, well, then we must believe the rest of the texts, right? And they're saying that they felt. Now in the text they say Brian Higgins, but it's easy to confuse Brian Higgins and Brian Albert because they're both named Brian. And there's a lot of shit going on in this case. There's a lot of names, so I can understand them, but seeing as Brian Higgins was not in the courtroom, sitting in the gallery at any point, he was just there to testify. We have to assume that he's talking about Brian Albert, that juror, he or she is talking about Brian Albert, right? So, and we also know that they stated that they felt intimidated by this person's presence, that the jury felt intimidated by this person's presence. I mean, cause and effect, right? So if we're sitting here and we're like, oh my God, he was just there, and it sure as shit looks like he was there to intimidate, because what other reason would there be? We speculated on that on this channel quite a few times. What other reason would there be than to intimidate that jury? And then when we hear that when we hear someone on the jury, independently state that they felt intimidated by his presence there, well, then what does that tell you? Because that's very fascinating to me. I'm just like, well, okay. So I get the whole the suspicions of the foreperson, because what if what if they were there to just simply intimidate the foreperson? You know what I mean? Considering that the foreperson apparently, allegedly, completely and totally dismissed the entire concept of reasonable doubt. That's how I'm hearing it, right? Is that this foreperson completely and totally dismissed the entire concept of reasonable doubt when it came to applying which is the one thing you need to apply as a juror to reach a decision of someone's guilt or innocence. Because in the American justice system, you cannot find someone guilty unless it is beyond a reasonable doubt, unless you are beyond a reasonable doubt that sure that person is guilty. And if the reason was as it stated that this person was dead set on Karen Reed's guilt because of the microscopic pieces of taillight found in his shirt, which was laying on the hospital floor initially and then wasn't logged into evidence for 3 weeks. And of course, for the trolls, well, it was sitting on some paper because it was wet. And it was sitting on paper in the evidence room, not in a bag, not anything. Not preserved in any traditional manner in which law enforcement would normally preserve evidence. It just wasn't. So, I mean, how can a former law enforcement officer be the foreperson of a jury and think that those 3 weeks that they're not even logged into evidence and you're just hearing someone talk on the stand, someone who was caught on multiple lies, multiple people sitting on the stand in regards to that evidence, lied on the stand, and were caught during cross-examination.
And there's no record of them logging this into evidence for 3 weeks. How am I not supposed to think that that's suspicious, that didn't cause reasonable doubt in a trained police officer's mind, who also is the chosen leader of this jury? He is the foreperson of this jury, meaning that he is chosen to lead those jurors and make sure that everyone makes their decision under the rule of law. Right? So how can the one person who's supposed to know how reasonable doubt works above everyone else, how can that one person completely and totally dismiss the concept of it as though it doesn't exist? Explain that shit to me. Judy Basteri, thank you so much. Thank you from Boston, Free Karen Reed. Thank you. I really appreciate it. Yeah, this is fucking wild, man. So, I mean, that whole jury situation is shady as fuck. The whole thing is shady as hell. Karen Reed should not have to go through another one of the sham trial. And let's not even forget that, like, let's focus again. Let's bring it back to the main reason here why this is fucking ridiculous. Because this should have never gone to trial in the first place. You know what proved that? The trial itself. The trial itself proved that this should have never even gone to trial, that there was nothing but reasonable doubt. So again, how am I not supposed to think that there's something suspicious about this foreperson reaching this guilty decision? It makes no sense. I didn't even bring up the ARCA guys, the crash daddies. I didn't even bring up those guys. This is wild, man. This should have never even gone to trial in the first place. This is what we need to not forget. Because I know a lot of the people who are just starting to follow this case because of the trial, and they're sitting there going, holy shit, this is exactly this is the conclusion that you should have taken from this. Absolutely 100%. You should have taken what you should have taken out of not hearing about this case and then watching the trial is, I don't understand how this could have actually gone to trial in the first place. I don't understand. And I don't even understand how any juror could say that she's guilty. It makes no sense. I don't understand how there could be a deadlock in that jury. It makes no sense. And the attorney general said not to take it to trial. This is insane. In essence, the Commonwealth's contrary position asked the court to close its eyes to the possible, or even as here very likely, existence of partial unanimous verdicts on some, but not all, separately charged counts to avoid the risks of juror coercion. Opposition at 13, quoting Commonwealth versus Roth, the Commonwealth utterly fails to acknowledge that Roth, Bluford, and a juvenile are all clearly distinguishable because they all arose in the context of lesser included offenses contained within a single charge. The Roth court's concern about coercion makes sense in that context. When the jury reports a deadlock on one charge, follow-up questioning regarding the possibility of reaching a verdict on a lesser included offense would imply that the jury should consider conviction on that lesser offense. But this logic does not extend to the present circumstances, and no existing precedent cited by the Commonwealth requires judges to disregard the possibility of partial verdicts when the verdicts would be on standalone separate charges such as those in the current indictments. Sorry, I'm rereading this because I didn't fully understand it. Allison Faye, thank you so much. Thanks for all you do. Remember, for 3 months. That's awesome. Oh my goodness.
I think we got a super chat.
Super chat.
I think we got a super chat.
Super chat.
Super chat. Super chat. I think we got a super chat. I think we got a super chat.
D Fox, thank you so much. Wow. Massachusetts Rule 27 states that if a case has multiple counts, the judge must read all other counts first before and only if there is a count that has to be declared a mistrial. Pre-disclosure, this is in my own words, but that is what it means. Okay, thank you. No, and thank you for putting it in your own words. That's how I read that too. So thank you so much for that. I appreciate it. So what it sounds like here is that they're basically saying that it makes sense that that the Commonwealth's concern for coercion adds up, but the context doesn't really apply to this case. The logic does not extend to the present circumstances, and no existing precedent cited by the Commonwealth requires judges to disregard the possibility of partial verdicts when the verdicts would be on standalone separate charges, such as those in the current indictments. Right. So basically, in essence, saying that it's not an excuse. It's not an excuse, that like that's just more word salad right there. Trying to say that it's coercion. It's not coercion. When we're talking about 3 lesser charges, we're not saying to sit there and pressure them to change their verdict, because that's not what they're doing. I talked about this when I went over the opposition. That's not what they're doing. They're not trying to pressure Judge Beverly Canone to pressure the jury to rethink a decision that they already made. She's saying, okay, well, we need to hear what you guys agreed on and what you didn't agree on. We need to find out if there were if there were unanimous decisions on any of the separate charges, or if you were deadlocked on all 3. That's it. That is not coercion in any way, shape, or form. Permits taking verdicts on less than all of the charges set forth in separate indictments, blah, 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 where a complaint or indictment in multiple counts charges multiple crimes. A general verdict could be returned as to one of the counts, despite deadlock on other counts. Massachusetts, blah, 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 blah. Reporters notes providing that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree upon. There is simply nothing coercive about asking a jury reporting a deadlock that fails to specify which counts the deadlock relates to the single question of whether its deadlock is on certain but not all counts, and if it has reached a unanimous verdict on any counts, which is exactly what I just said. Affirming trial judges taking of partial verdicts on 2 of 4 separate indictments, and observing to conclude the jury could have felt pressure to convert provisional verdicts against the defendant into final ones, and to abandon all doubts that they may have privately entertained runs counter to the clear instructions of the judge, and amounts to mere speculation without any support in the record. Affirming partial verdicts taken after judge asked jury whether it had reached a verdict on any of the indictments. The inflexible prohibition on judicial inquiry regarding partial verdicts advocated by the Commonwealth would inevitably undermine defendants' important and constitutionally protected interests in being able once and for all to conclude their confrontation with society through the verdict of a tribunal they might believe to be favorably disposed to their fate. Blah, 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 blah. The danger of unfairness to the defendant from multiple prosecutions exists when a trial is aborted before it is completed, as well as when the defendant is actually acquitted. The Commonwealth's proposed rule would also undoubtedly hinder law enforcement interests by precluding courts from asking whether a jury may have reached a guilty verdict on some but not all standalone counts. The Commonwealth's attempt to shift blame to the defense overlooks the black letter rule that the prosecution alone bears the heavy burden of establishing manifest necessity for a mistrial. The defense's request for a Tui Rodriguez instruction did not, of course, reflect any implicit concession that the jury was deadlocked on all counts, nor did it commit the defense to any position regarding whether the court should sua sponte declare a mistrial. A discussion with counsel such as that, occurring twice earlier in response to jury notes and either the consent of the defendant to a mistrial or further judicial inquiry of the jury, instead was required. It is indisputable that the court provided no opportunity for defense counsel to be heard regarding the declaration of a mistrial, as opposed to the appropriateness of a Tui Rodriguez instruction. In short, mere silence, absent an opportunity to object, does not amount to consent. The cases relied upon by the Commonwealth are readily distinguishable on this basis, or even support the defense motion. Holding that where the trial judge did not ask defense counsel to comment on the possible declaration of a mistrial, the lack of an objection from defense counsel cannot be construed as consent to such action. And then they cite other cases here. The judge declared a mistrial upon the defense request, Pellegrin versus Commonwealth, finding the defendant plainly had the opportunity to object, where the mistrial was declared after the voir dire and colloquy, I don't know that word, after the jury was cleared from the courtroom. Okay, so yeah, that's basically just reiterating what I was talking about earlier. It's just that they're saying just because we didn't object, it doesn't mean that we consented to the mistrial. I mean, isn't there other opportunities where the judge goes, okay, well, I'm declaring a mistrial. Are there any objections? Yes, Your Honor. No, Your Honor. That didn't happen. I'm declaring a mistrial. The jurors are dismissed. I'm sending you home. Goodbye. That was it. That was fucking it. Colloquy. Okay. Oh, right on. Oh shit, Microdot's got a Galera shirt. Yeah, I need to get a Microdot shirt. I really need to. Hell yeah. Yeah, man. There's merch. I'm terrible at selling my merch. I'm like, whatever. Buy it. I don't care. Don't buy it. Yeah, it's this is basically saying just because we didn't object didn't mean that we consented to the mistrial. We didn't have an opportunity to object to it. You didn't give us an opportunity to object to it. You didn't specify whether or not there were that is Judge Beverly Cannoni's that is her responsibility. It is not the defense's job to call the judge out on her not doing her job. They are not her supervisors. They will do it from time to time, but it's not their job. That's just extra good lawyering. When they end up going, well, wait a second, Judge, all due respect, you didn't do this and you didn't do that. When that shit happens, they're taking a risk. But They feel that the risk is worth it because something is being that they're not sticking up for they're trying to stick up for their client because the judge is making a decision or not making a decision that could violate their client's rights. So they'll step up at that point and go, hey. Yeah, the merch link is in the description. That's what they'll do. They'll go, hey, wait a minute, judge, all due respect, but they're afraid of, I mean, I wouldn't say that they're afraid, but there's always the risk that you're going to piss the judge off. There's always the risk that the judge is going to get annoyed with you, and start looking at things a certain way and start looking at you a certain way. And then she's going to start letting that influence her decisions, even though she's not supposed to do that. But we know that she's already got personal feelings about Karen Reed's defense. We already know that Karen Reed herself gets under Beverly Cannoni's skin. Something funny, Miss Reed? I mean, so I mean, these people have not. These people are Karen Reed's defense have not done anything wrong here. People came forward and approached them. Jurors came to them and were like, hey, wait a minute. In good conscience here, as Americans, we can't sit here and good conscience, you selected us for a reason. And that integrity that we were selected for brings me to you to tell you that on counts 1 and 3, we unanimously agreed that she was not guilty. And we want to know what can be done about this. Michelle, thank you so much. The jurors should have sent a note asking the judge about the juror form if they didn't understand it. Why wouldn't the foreman and ex-cop know this? Right. Yeah, good point. Great point. But maybe the foreman, I mean, again, we don't know what the hell went on in that deliberation room. We have no idea. What if the foreman was just like, yeah, I got it. What if the foreman was dirty? What if the foreman was a plant? Now, I'm not saying he was, and I have no evidence to back this up. And I don't even necessarily suspect it. I kind of suspect it a little bit. I feel justified. If I decided to suspect it, I feel justified in doing so for the reasons I explained earlier. But the thing is what if he was a plant? And he was in that room and he was just like, hey, you know what? This clearly, I got this. Don't worry about this. Yeah, you just do this and that's what that means and blah, blah, blah. And it's just, who knows how he fucking quarterbacked that shit in the jury room. And he voted not guilty on the first count. Right. It's count 2 that's all confusing. In only one case cited by the Commonwealth, Fuentes versus Commonwealth, was the defense, as in this present case, afforded no opportunity to be heard before mistrial was declared. But there, the Commonwealth fails to mention the crucial fact that the jury's note preceding the declaration of mistrial expressly stated that the jury could not reach a unanimous verdict as to either of the two indictments. In those circumstances, while the more prudent course would have been to consult with counsel, the record did not show that such consultation would have produced any fruitful alternatives. Here, the opposite is true. The note did not expressly state that the deadlock applied to all counts, and it is patently clear from the affidavit submitted in support of the defense motion that consultation with counsel, I had it right the first time, with counsel may well have produced a fruitful alternative, namely inquiry regarding whether the jury had reached a unanimous verdict on any of the 3 counts, which, according to the information from jurors A, B, C, and D, would have resulted in acquittals on counts 1 and 3. In any event, Fuentes did not alter the court's clear obligations, repeatedly reaffirmed since the decision before declaring a mistrial. Counsel must have been given full opportunity to be heard, and the trial judge must have given careful consideration to alternatives to a mistrial. Right. It just doesn't apply. Let's see here. Cosmic Blue, thank you so much. I absolutely love my Glera merch. Right on, man. That's awesome. I'm glad you guys like it. Thank you. I'm terrible at coming up with ideas for it, but you know, I have a couple of ideas, but we'll see what happens. Right. I mean, so the Commonwealth cites no support for its suggestion that an attorney who receives a call post-trial stating that the jury had acquitted his or her client must simply hang up the phone and not act upon that information. The jury had acquitted his or her client must simply hang up their phone and not act upon that information. The jury's agreement that Miss Reed is not guilty on counts 1 and 3 reflects the results of its deliberative process. Motion at 4, citation omitted, not the contents of jury deliberations or thought processes of jurors. Right, exactly. Like, they don't give a fuck. This is the thing, is they don't give a fuck. They're not bringing up at all. They don't give a fuck about the fact that Brian Albert was in that courtroom and intimidating the jurors. I mean, they might give a fuck about it. What I'm saying is they're not showing this in their motions. They're not focusing on this at all. They're saying, hey, we're not trying to fucking, pick apart. Don't get confused by those text messages. All we're trying to focus on is that those text messages prove that jurors were only deadlocked on count 2. And the other 2 counts, she was found unanimously not guilty. That's all we're focused on. We're not focused on whether or not anybody was intimidated. We're not focused on any of that shit. We're not trying to get you to pick their brains and find out what they were thinking when they made that decision. None of that shit. All we want is to put forward the fact that you called a mistrial without finding out and specifying whether or not, having the jury specify which counts, which charges they were deadlocked on. If it was all or just one. All, 2, or just 1. So that's all they're calling her out on. We're saying, dude, just acknowledge the fact that you called a mistrial without specifying, without thoroughly going through each charge as to what the decisions were from the jury on all 3 counts. That's it. It's not all that complicated. We're not saying any of this shit. We don't give a fuck about the hearsay or blah blah blah. We're saying we can get these jurors to come forward, sit on the stand and testify under oath that this is how they voted. That's it. Remarking that trial judge was rightly loath to examine the entire panel to attempt to determine the impact of the errant juror on the rest of the jury. The defense is not relying upon jurors to attest to any particular statement made or incident that occurred during the jury's deliberations. Exactly. The effect of anything on any juror's vote or any juror's mental processes concerning a verdict. Rather, the defense is relying upon the simple fact of the jury's agreement that Miss Reed is not guilty on the relevant counts. Blah, 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 permitting juror testimony that a mistake was made in entering the verdict on the verdict form. The permissible subjects of juror contact listed by the Commonwealth are not exclusive, and the Commonwealth fails to cite any authority establishing that the fact of a jury verdict constitutes a prohibited subject matter under Rule 3.5. At the same time, the Commonwealth criticizes the defense for perpetually infringing upon the jury's deliberative process. It also paradoxically faults the defense for reliance on hearsay. But the affidavit by counsel in Commonwealth versus McCallop, 485 Massachusetts 790, 799, 2020, attesting to alleged juror bias was no less hearsay, and the Supreme Judicial Court squarely held that it entitled the defendant to further inquiry on the subject. And that, again, further inquiry, they'll settle for that. The defense submits that the same result is warranted here for all the reasons set forth above, as well as in its opening motion, supplemental memorandum, and attached affidavits. The defense respectfully requests that his honorable court issue in order dismissing counts 1 and that this honorable court issue in order dismissing counts 1 and 3. So that's it. Yeah, I mean, at least, like, if you're not going to dismiss them, if you're not going to dismiss those charges, well, then at least entertain the inquiry moving forward. Like, let's look into it before you make the decision. Let's look into it. That's all we're asking you to do. And I don't think that's unfair at all. It was, after all, Judge Beverly Cannoni's mistake to simply not go over each particular charge before calling a mistrial. That's it. I mean, it's not even that, it's not that complicated. Now, let me go over and I guess, what do we got? We got a hearing on the 22nd, right? So this was interesting. Wait, is this new? Oh, oh shit. This is like discovery from Turtle Boy's case. Oh shit, folks. We're about to have a little fun here because I haven't seen this shit yet. So yeah, we'll get into that in a second, but I gotta see this because I'm
Got the people? No, that's just yours.
okay. Here we go. Hold on. So this is Turtle Boy getting booked.
You guys ever find him driving that Ford Edge? I'm not gonna talk to you about it. I just want to read.
So as he's talking, I think he's talking to Tully right now. You gotta love this shit. Like, I think he's talking to Tully right now, and so Turtle Boy's just sitting there chilling. He sees an opportunity. He's like, I can interview these guys. Basically, you know, like, I know this is being recorded. So he's like, did you guys ever find out who's driving that Ford Edge? That shit is fantastic.
I'm just wondering if you found it. Got the paperwork? No, that's just yours. Okay, hold on. Let me get the R1 and all that. It's found 3 hours. It was seen 3 hours before the cop was found there. So it seems kind of important. But I know this is a priority too, right?
Right now, I'm booking you, and you're in custody, so I'm going to try and get you out of here quickly as I can.
I'm just the middleman.
Let's do it.
All right, so that's it. Let's watch that one more time.
Driving that Ford Edge. You guys ever find him driving that Ford Edge?
I'm not going to talk to you about it.
I just wondering.
Can't read, please.
I'm just wondering if you found it.
Got the paperwork?
No, that's just yours. Okay, hold on. Let me get the R1 and all that. It's found 3 hours. It was seen 3 hours before the cop was found there. So it seems kind of important. But I know this is a priority too, right?
Right now, I'm booking you, and you're in custody, so I'm going to try and get you out of here quickly as I can.
Just the middleman. Let's do it.
So this dude, I mean, why not? You know, I got you right here. So I might as well ask you. Did you guys ever find out who's driving that Ford Edge? I mean, seems kind of important. I mean, he was found. I mean, it was seen 3 hours before there was a dead cop found. So I think, yeah, this is very, very reminiscent of that, isn't it? We're all on the same joke, right? This is basically Turtle Boy's having like almost an identical reaction to sitting there and booking the way that Karen Reed was in that footage. Like, yeah. So this priorities, right? You got me sitting here, but you're not looking for the Ford Edge. This is awesome. This is great on you. Fantastic, guys. Top notch. You guys are the top cops. Fantastic. All right. And then there's another one here. There's one more.
Any tattoos?
No.
Any aliases?
Sure.
What is it?
Daddy.
Yeah.
Uncle Turtle Boy.
Dr. Turtle Boy. Like
Dr. Turtle Boy.
There you go. See, if I'm Turtle Boy right now, if I'm Turtle Boy and I go by all those aliases, which he does, technically, I'm gonna make this motherfucker sit there and write those down. Okay, you asked. What are my aliases? Daddy, Uncle Turtle Boy, Dr. Turtle Boy, the Intimidator,
and Clarence Woods Emerson. Oh yeah, that's it. You got it. Thank you.
I'll probably put that with the inventory. Any
Let's watch that one more time.
Tattoos?
No.
Any aliases?
Sure.
What is it?
Daddy.
Yeah.
Uncle Turtle Boy. Dr. Turtle Boy.
Holy fucking shit, bro.
And Clarence Woods Emerson. Oh yeah, that's it. You got it. Thank you.
I'll probably put that with the inventory.
Fantastic. Please keep posting these, Turtle Boy. These are fantastic. Like I can't wait to see the body cam footage, all of it. Now I'm just addicted. I want all of that discovery from his case. I can't wait to go over all of it. I can't wait till it's public and I can just go over every fucking bit of it because that shit right there it just left me wanting more. I can't wait to see what the actual situation was like. This is when he was first arrested. Monique, this is when he was first arrested and charged. This was right in the beginning stages of me covering this case. So months and months and months ago. This is before he even actually went to jail. He was arrested and then he was out on bail the next day, and and then around Christmas, he gets locked up. October-ish last year, right? Thank you, Scott McGinnis. Is it all out there now? Oh my God, is it all out there now? Wow. Oh, that's gonna be fun. Yeah, you guys are gonna be seeing a lot of me. So here he posts that Vinnie Politan's producer has apologized for inviting Kate Peter on Vinnie Politan's show and says she will not be invited on again. She was unaware of Miss Peter's documented history of child abuse and criminal record. And so the text is just kind of like, I mean, here is, Turtle Boy texting her saying, "Hi, Marina. Last week you had a woman named Kate Peter on as a guest with Vinny and Julie Grant. My mother died 2 weeks ago, and this is what Kate Peter posted about her. Kate also lost 2 of her children due to years of neglect and abuse. Were you aware of this when you invited her onto the show and gave her a national platform? And do you intend on inviting her again?" And so Turtle Boy, I mean, they know who Turtle Boy is. They've had him on. So basically, this is a quote. You know what I mean? Like, this is basically a quote. And she knows it. So she says, "No, I was not aware. Apologies. No, I do not intend on inviting her again." So there's that. And just a reminder, this is what she posted, what Kate Peter posted. Gross. But as disgusting as I find this, I think it's necessary to put it out there into the world as much as possible because people need to know how disgusting she is. And it says here, the world is a better place without Turtle Boy's mother. Thank God she is dead. I'm hearing that after using her to try to get out of jail, it failed because no one cares what that useless, decrepit piece of shit had to say about her useless son. That Turtle Boy killed her with all the stress and shame he caused her. First good thing he's ever done, in my opinion. Brian Riccio at least had family who cared, not so much for mannish Mary. So yeah, this is somebody who Court TV had on their channel. And now, okay. So someone addressed this, like someone in the comments addressed this. Let me show you guys what that said here. So someone clipped this because they super chatted Vinnie Politan on his live stream, not on his show Court TV, on Court TV, but on his own live stream on his YouTube channel.
The note was specific. Mom's huge feet on X.
All right. So Mom's huge feet on X comments here. Will you address the controversy over your guest last night? So I guess this is the next day. And I guess a lot of people were pissed off about them having Kate Peter on Court TV, and rightfully so. I mean, I get it. But here, Kate Peter, her blatant homophobia and child abuse allegations, you're getting a lot of backlash online, as well as calls for a boycott. Okay, well, this is how Vinny responds to this super chat.
X. Will you address the controversy over your guest last night, Kate Peter, her blatant blah, blah, and blah, blah? You're getting a lot of backlash online, as well as calls for a boycott. Oh. Are you going to stop? Here's what I would say to Mom's Huge Feet on X. Do you or do you not believe in freedom of speech?
What?
Do you or do you not believe in freedom of speech?
Now, this is what bugs me about Vinny. Okay. Now, I listened to this earlier and I was just like, oof. Because we're talking apples and oranges here. This isn't about freedom of speech, and it's not about people disagreeing. It's not. It's about Court TV having credible people on their channel and vetting their people properly before they have them on there. That's the issue. Because my biggest issue with Court TV is that every single person, you know what's fucked up? What's fucked up is that Plevin is the most well-versed in the Karen Reed case out of any of the other experts that they've had up there. Like any of the attorneys that they've talked about, that they've had on there that weren't law tubers already talking about the case. I'm talking about just the panelists that they randomly bring up and say, oh, he's a law professor from blah, 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 blah. And okay, well, but they don't know shit about this case, right? They get briefed in whatever fucking virtual green room is going on there, I would assume. And that's it. And so, you know, you're just spinning a lot of bullshit. I mean, it was heartbreaking, dude. I remember back when they were talking about the Celebrate data. The first thing that like Vinny talked about how there was the 2:27 a.m. search because he had just recently had Turtle Boy on, I think, and he had somebody who I even respect a lot, Mike King from Profiling Evil. Dude's awesome, but he was up there and he didn't know what the fuck he was talking about either. Now, that's not to say that Mike King doesn't know what he's talking about. Mike King is somebody who I respect very much. He's an actual criminal profiler, and his stories are absolutely fascinating. But when he talked about this case, I mean, sorry, Mike, but it was clear that you were just up there to promote your own shit, because Court TV is a great place to do that. And it's just like, at least you're going to sit here and talk about the 2:27 a.m. Celebrate data and be like, well, if the experts are saying that that's what it is, then that's what it is. And I'm just like, well, did you look into this at all before you formed an opinion and just went ahead and just said, hey, if that's what it is, then that's what it is? That really annoyed me. But the problem here, Vinny, is not that let me just let you keep talking here before I go on my rant.
Do you or do you not believe in hearing both sides of a controversy? Do you or do you not want to know what the other side is saying so you can respond? See, here's a problem, and this trial has fallen into the trap that the world, not just our nation, but the world has fallen into when it comes to really the world of politics, right? You're either left or right, and if you're right, you only talk to other right people, and if you're left, you only talk to other left people, and you listen to each other in your bubbles. You never hear one another.
See,
you're totally working in separate worlds.
He's right when it comes to discussing politics, for the most part. Not really. Actually, now that I think about it, he's actually just dead fucking wrong. But people are set in their minds, you know? Like, yes, absolutely. Does that happen? But here, like, Plevin has been in my chat before. Plevin is welcome in my chat if he wants to be here. I mean, he's going to have to face the fact that there's going to be a lot of people who clearly disagree with him and fucking just plain think he's a goddamn clown. But he's welcome in the chat anytime he wants. Because again, you know, I say don't boot him because maybe he'll learn something. But to sit here and act like, you know, well, you know, the reason why you have, and that's the thing is, I believe that. I believe Vinny when he says what he's saying here. I believe Vinny is merely has their producers have people come on there who have different viewpoints on the case, and he lets them hash it out. But he doesn't do any research as to how well versed they are in the case. He doesn't do any research as to how credible they are as far as their character goes. They don't do any research like that at all. They just wing it. It's crazy to me that they're as successful as they are, and they do a fucking glarer where they just fucking just say, all right, well, let's piss in the wind and see how this goes. You know what I mean? I always thought that the reason why I wasn't more successful was because I was so fucking disorganized. It turns out it doesn't matter how fucking disorganized you are. Because Court TV, when it comes to guests, they're completely fucking disorganized because there's no fucking way that they would ever want to be considered even so much as partnered in any way, shape, or form with somebody like Kate Peter. And maybe they knew. Maybe they knew. You know, that there's some personal shit going on. Because the thing is I don't trust Court TV. I don't trust Court TV to differentiate the fact that literally everyone, fucking everyone, who's been following this case pre-trial, who believes that Karen Reed is guilty, has some sort of vendetta against Turtle Boy. They hate Turtle Boy. That is the one thing that they all have in common. Besides the fact that they think Karen Reed is guilty, besides that, they have the one thing in common that they all fucking hate Turtle Boy. So why wouldn't they apply this logic when vetting a guest? Because it just tells me that they know better. They know better. They are, well, let's get a Turtle Boy hater up here. Let's get a Turtle Boy hater up here and see what they have to say. Because they're just another fucking tabloid goddamn channel that's just looking for drama. They're hoping for the drama to happen. They're hoping for somebody to come up there who's kind of unhinged but controllable to where they could go, hey, hold on, let's chill out on the name calling here. This is a news station, and we don't do that here. They want that shit so they can go, hey. No different than Jerry Springer wanting fights to happen and then having security there to break it up and go, hey. Eventually, Jerry Springer just said, fuck it, and fucking just had a bell ringing sound effect to get people to fight on his stage. Eventually, he just didn't give a shit. But at first, it was just like, okay, well, let's have this facade where we'll have somebody lose their shit and then they fight, and then we go, hey, you have to conduct yourselves here. This is not how you handle yourself on my show. And then everybody goes, yeah, Jerry, you handle your show. You do you, boo-boo. That's what they always do. Little Irish Girl, thank you. He avoids the question and talks down to her all at once. He totally does. He absolutely avoids the question.
That's not the way it works. That's just not the way it works. Not in a trial. A trial is never in two separate bubbles. The bubbles intersect. Both sides have to hear one another.
What's up,
Both
Mega
sides
Monster?
question one another.
Good to see you.
And that is the model for my show and what I do. How on earth could I do a show about legal controversies and give you one side of the story? I've never done that. Even in cases where the evidence is overwhelming on one side. Take the Madeline Soto case. I will report and talk about every potential defense that Stephen Stearns can bring up in that case. I absolutely will. That's my job. It's also the nature of a trial. Could you imagine a trial where only one side gets to speak? Oh, you know what that's called? That's called the grand jury. And most defense attorneys don't like the grand jury because only one side gets to speak. And the reason that a grand jury does not become a conviction is because only one side is speaking without cross-examination. Like, what you're saying about not wanting to hear the other side, to me, that's like, doesn't make sense to me. Doesn't make sense to me. And I understand there might be some shows or some people that's how you want to talk about the case or hear about the case. That's fine. That's fine. And there may be some that do that just look at it from one perspective. That's not me. That's not me. And this is in cases that are overwhelming, like overwhelming evidence, like the case out in Idaho. Obviously, we're going to argue everything, despite the fact that his DNA is on a knife sheath that is found at the crime scene in a case it's a stabbing. Like, yeah, despite that, we're going to talk about all the defenses and all the possibilities.
Well, sure.
And all the arguments that are being made on both sides. Of course I will. Of course I will.
Nobody's fucking denying that, dude. You know what I mean? Nobody's faulting you for that. Nobody's faulting you for having different viewpoints to where they can have a panel discussion. That's great. That's why people watch the show. The problem that people have is that you have people on there who are you're giving people a voice who are going to share misinformation. Because people assume that they're experts. All right now we've got Kate Peter on, who's been following this case, and she's got a YouTube channel called the Masshole Mafia. I mean, how do you sound? How do you sound? Does anybody even have that? Like, I don't even have that. Did they take it down? The one with Kate Peter, the Court TV one with Kate Peter? It's just so fucking silly, dude. It just kills me, man. Man, I wish there's I'm just gonna start. If there really is a bunch of discovery available, like more video available of Turtle Boy's fucking arrest, like body cam footage and shit like that. Oh man, I'm dying to go over that. It was rehomed. I mean, I'm not making excuses. Vinny, listen, I don't know what type of person Vinny is in real life. Might be a nice fucking guy. I don't know. All I know is I understand people's frustration because this case requires some real deep diving, you know? And it's just frustrating when you hear people who have all this fucking law enforcement experience and shit like that. Like Mr. fucking this is Bill Cannon and 28 years, New York City Police Department, and I'm gonna do a deep dive onto the John O'Keefe Karen Reed case. And I'm telling you, I did a deep dive, and she's absolutely guilty. And you people are idiots. Go back to work at the Piggly Wiggly, and fuck all of you. Like, fuck, you know? So when we see people, that's the expectation we have, dude. We have the expectation. If you're going to minimize Turtle Boy as a blogger and not an independent journalist, right? An award-winning independent journalist, if you're not going to acknowledge him as that and minimize him as just a blogger, well, then do better work than he does. You know what I mean? Exceed the standard. Is that unreasonable? Is that fucking unreasonable? Like, you're going to sit here on one side of your mouth and you're going to be like the blogger known as Turtle Boy, right? And then you're going to have a bunch of fucking experts on there who haven't even done even the fucking slightest minute fraction of a fucking cell of what Turtle Boy has done in regards to this case, as far as research goes. I mean, in investigations, you have no fucking, you can't even touch it. So, like, I mean, if you're these investigators, you guys are all these experts, you people on court TV are all these experts, and you people on fucking on Law and Crime or wherever the fuck, and you're just, oh my God, we've got these experts, and this person wrote this book, and blah 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 blah. Who fucking cares if they don't know anything about the goddamn case? You know what I'm saying? Like, think about it, dude. Like, if I had Albert Einstein sitting here right fucking now, right? And I fucking handed him my fucking iPhone and was like, here, you know what he'd go? He would go, fascinating. This is fascinating. But he's not going to fucking tell you how it works. He would have to actually fucking take the goddamn thing apart, ask questions, find out what they're using to make it fucking work the way it does and do the things that it does. But Albert Einstein might be 100 times fucking smarter than the person who thought of the iPhone. But you sit those two people together to talk about the iPhone, Einstein's going to go, I don't know. I don't know. I have no idea. It's called the I what? What? That's all he's going to do. He's not going to know what the fuck. You know what I'm saying? Does it pertain to science? Absolutely. Science is the reason this thing exists. For sure. Is Albert Einstein arguably the greatest scientist of all time? Yes. That doesn't mean he's going to know shit about an iPhone, is he? So, like, stick to having someone like Melanie Little on your panel on Court TV. Who knows what the fuck they're talking about if you don't know? Stick to having people like that. Stick to having somebody like fucking Emily Baker or Andrea Burkhart or Mark Betterow. For fuck's sake, Mark Betterow. Don't just get these random fucking lawyers with fucking who are law professors who go, when I look into this, you think Einstein's going to be that fucking arrogant? Well, this looks like could be is there liquid inside? I don't know if there's liquid inside that makes this work like this, but he's not going to fucking know. He's not going to know what the fuck he's talking about. So if Why can't a successful producer? Because the thing is I hope they learn from this case because they lost a lot of viewership. Like Vinny lost a shit ton of respect from people who liked Vinny already and then just started watching the Karen Reed case and are watching him sit on the fence. And they're going, dude, how are you not seeing exactly what I'm seeing right now, dude? You just fucking watched the goddamn trial. Never even heard of this case. How long have you been talking about it? And you don't see that she's innocent? And you just can't, you're too scared to say that there's no reason why this should have even gone to trial in the first place? Why are you too scared to say that? That's what I want to know. Why is it that Vinnie Politan is too scared to simply say, I mean, this should have never even gone to trial? And then have experts who disagree with him. Sure, great. But at least call it how you see it, dude. Because that's what I'm calling Vinnie Politan on. I'm calling him out on not saying what he thinks. Because I know that he knows that Kara Reed is innocent. I fucking know it from my balls to my bones. I know that Vinnie Politan absolutely believes Karen Reed to be innocent. I can tell. I can feel it. That's what's so frustrating is I could feel and tell. I can sense him sitting there and acting as though he's, I don't know. You know, I'm just going to do my job, okay? I'm going to ask questions, and some of you guys are not going to like my answers, but I've been doing this a long time, and when it comes to the law, okay, you got to be fair. And if I'm on a show called whatever the fuck my show is called, because I forgot, I don't know, whatever the fuck my show is called, on a channel called Court TV, well, then I have to treat everyone fairly, don't I? Okay, man. Great. Sure, you do. I get it. Sure. But at the cost of just ignoring blatant facts. I mean, if it's Court TV and you're interested in justice, right? Didn't you, if you're going to treat this like if you're going to approach it like you would any other court case, then why is it guilty before innocence on every other case? And now on this case, closing arguments. Thank you. And now on this case, it's just like, oh, this is a tough one, guys. I don't know. This is a tough one, guys. Is Karen Reed guilty of second-degree murder? I'm here to ask the question, guys. But that's all I'm here to do. Bro, like, I know you're aware of all the evidence, dude. Like, what are you talking about? Like, I know you're aware of it all. Like, why? Like, nobody here thinks that Vinny's stupid. That's what's frustrating about it. That's why everybody's like, fuck Vinny Politan, dude. Fuck that guy. I'm done with him. That's why people are saying that. You know? That's why people are saying that. Fuck Court TV and fuck Vinny Politan. They're saying fuck Court TV because not just because of Vinny Politan, but because of Jennifer Coffindoffer and because of Julie Grant. That too. Like, I mean, because I try to be empathetic. I do. Because I got to wonder what it's like for Vinny, dude. What's it like for Vinny? What's it like for Vinny to fucking have to like talk to someone like Julie Grant, you know? Like, what's it like? What's it like to sit there and have to clean up the shit that she made, the spray shit all over the toilet that she made, that he's got to go fucking sit on now. You know, because she was on earlier talking about the same goddamn case and not making any sense and completely and totally contradicting anything that is common sense. And now Vinny's got to sit on that shitty toilet seat. And maybe I'm giving him too much credit. You know what I mean? Maybe that's how it works. Maybe that's how they keep their viewers. You know, and they just play those fucking mind tricks on their viewers, like, oh, well, let's just keep them watching. You know, let's just keep them watching. No matter what, we're just going to keep them watching. This way, when I go on with closing arguments, everybody's still pissed off about what they heard Julie Grant's bullshit coming out of her mouth. They heard all that shit. And so now they're going to watch my show all pissed off, seeing what I'm going to do. Like, what do they got? Like a good cop, bad cop, like dynamic going on? Because I entertained that shit when Vinny was like, I'm just here for the truth, people. I'm only here to get to the truth. Okay. But see, here's the problem, Vinny, is we all think you know the truth and you're just not saying it. That's the issue that people are taking with you. That's all. We're past the point of knowing the truth. We all know the fuck happened here. Like, now, nobody's saying to fucking point fingers at a McAlbert and say they did it. Nobody's saying that. I'm not doing that. I don't fucking know who killed John O'Keefe. I honestly don't. I have no clue who killed Boston police officer John O'Keefe. All I know is it wasn't Karen, and it was somebody inside that house. Because who else could it possibly fucking be? It's just silly, man. Yeah, man. It's just mind-blowing, dude. See just all the blatant ignorance, man. It's just mind-blowing. Now I'm gonna go ahead and call it, but before I do, make sure, guys, those of you who are members, I'm gonna be live again in just over an hour. And it'll be a members only. Now you'll be able to see it. Everybody, it'll be available for everyone to see. But it's not related to Karen Reed, although the subject may come up in natural conversation. But I'm really, really interested in exploring the whole Tenacious D news. Some of you might think, what? Why? Well, if you guys are just looking for a hangout, just to talk and discuss a particular current event, that's what I'll be talking about. But in order to comment, you do have to be a member. So, but members, those of you who are members, I hope to see you there to interact with each other and myself in the chat. But yeah, that's what I'm going to be doing at 5 p.m. Eastern Standard Time. And yeah. So guys, I appreciate you. Thank you so much. And yeah, I know they canceled the tour. We're gonna go over all that stuff. This is just very funny to me. Yes, and yes, sorry, too bad. I do think it's funny. I think it's absolutely hilarious. So anyways, guys, you are fantastic. Thank you, guys. Make sure to hit the like if you haven't already. It really helps me out. And subscribe if you're not subscribed already. Appreciate you. And to all of the people who donated and showed support, thank you guys so much. Your support means the world to me. It really does. Thank you guys. You guys are absolutely fucking fantastic. But I am going to call it. I love you guys very much. And we will do this again very soon, my friends.